So Judge Beverly Cannoni has read what's called a Tui Rodriguez charge. I have Jay and Bob Mata and Ali Mata in the background. So, hold on, let me pause that. Spinning in their wheels. Like a car tire spinning in the snow, going nowhere. So my understanding is that by the end of the day, the jury will come back with a hung jury, which is what they also call a mistrial. So what that means is if all the juries cannot unanimously agree, meaning everybody in the room agrees to whatever verdict, not guilty, guilty, or the lesser charges, then, and what their note said was that they were basically dead set in their views, and it's not because they don't understand the evidence, it's because they have fundamentally different views and opinions of that evidence. So she sent them back. You're only allowed to send jurors back 2 times. Then she read what's called like a Tui Rodriguez charge, which I'm going to play here. And so my understanding is that they will be back by the end of the day, and I'm quite sure it'll be a hung jury, which will be a mistrial, which means that the Commonwealth will have to decide, are they going to charge her again, or are they going to drop the charges? And will we ever find out what the split of the jurors was? I don't know, but here's what happened today so far. So now they're back in deliberation. Jury is in hour 23 of deliberation. It is local time, 11:26 a.m. The fan is spinning in the Norfolk courtroom.
That's a good question.
You are unmuted.
Thank you. We're back in session. May you seated.
We're back on the record on the Karen Reed, Your Honor. We've got a question from the jury.
All right. So, Mr. Lally, I'd like to hear from the Commonwealth first about due and thorough deliberations.
I'm sorry, I didn't hear the last part.
I'd like to hear from the Commonwealth first about your view on whether the jury has conducted due and thorough deliberations.
Your Honor, while I understand that they have been at this for a while, I would submit that they have not, and I would ask the court not to make such a finding. Reasons for that, Your Honor, this jury heard, I believe, about 29 days or so of testimony, 657 different exhibits marked as evidence, 74 different witnesses who testified before them. And while I believe they've been out for somewhere in the vicinity of 22 or 23 hours, what I would submit to the court based on all of that, as well as the complexity of the issues presented to them, they really haven't even had 1 hour of deliberation equivalent to 1 day of testimony to each of the days of testimony that they've heard. So while they have been at it for a while, I would submit that based on the evidence and testimony and witnesses and the complexity of issues in this case, I would submit that they have not done a thorough deliberation up to this point.
Ms. Giannetti?
Our view is that it's time for Tui Rodriguez. They've come back now twice, indicating essentially that they're hopelessly deadlocked. The content of this latest message is that they have been over all the evidence. Previous message said they did an exhaustive review. This time they said that they have fundamental disagreements about what the evidence means. And it's a matter of opinion. It's not a matter of lack of understanding. This court, when you sent the jury out, encouraged them not to take a straw vote, encourage them to go over all the evidence in a very methodical manner. I think all indications are that they've done that, and this is what Tui Rodriguez is for. We asked the court to get it.
Yeah. All right. I think this has been an extraordinary jury. I've never seen a note like this, reporting to be at an impasse. I do find that they're now, with the additional time that they went out without coming back Friday saying that they were deadlocked, is due in thorough deliberation. So I'm going to give Tui Rodriguez. So are they ready to come in, Jody? So why don't I take a recess?
Take a recess, please.
All right.
And then Nancy.
Court of session, please be seated.
All right. So, jurors, I am in receipt of your note. Judge Cannoni, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. So, Mr. Foreman and members of the jury, I have an instruction for you. Our Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking in all cases, absolute certainty cannot be attained, nor is it expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusions of the other jurors. Still, in order to bring 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that this case be decided. You have been selected in the same manner and from the same source as any future jury would be selected. There is no reason to suppose that this case will ever be submitted to 12 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced at another trial. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. If you are left with a reasonable doubt as to any essential element of any indictment, then the defendant is entitled to the benefit of that doubt and must be found not guilty on that indictment. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who would find the defendant not guilty should consider whether the doubt in their own minds is a reasonable one, if it makes no impression upon the minds of the other jurors, who are equally honest and equally intelligent, who have heard the same evidence with the same attention, who have an equal desire to arrive at the truth, and who have taken the same oath as jurors. At the same time, those jurors who would find the defendant guilty ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or sufficiency of the evidence if it has failed to convince the minds of their fellow jurors beyond a reasonable doubt. I will now ask you, Mr. Foreman, and members of the jury to return to your deliberations with these instructions in mind. And as with my final instructions and the supplemental instructions I sent in, I will send in a copy of this charge as well. All right, so may that be marked, Madam Court Reporter, please. All right, so Thank you. We'll send you folks back out to deliver.
All rise for the court, please. Jurors, follow me.
You are muted. Goodbye.